Judgment in the appeal, John Mander Pension Trustees Limited and Commissioners for Her Majesty's Revenue and Customs.
Lord Sumption will explain the decision of the court.
This appeal is about the tax treatment of pension schemes that were approved by the Inland Revenue under the system which operated before 2006. Ostensibly, the question is, for which tax year should a special charge to income tax be assessed? In fact, however, there is rather more to it than that. Before 2006, pension schemes could obtain Inland Revenue approval if they satisfied certain criteria. Approved pension schemes enjoyed important tax advantages. Contributions to them were exempted from income tax, and no capital gains tax was payable on gains made on assets within the scheme. The downside, however, was that benefits were subject to certain restrictions. In particular, they could only be taken on retirement over a specified minimum age or on death if earlier, and they had to be taken in the form of an annuity. Some people took advantage of the system to avoid tax. They set up a small pension scheme, usually for the controlling shareholder and chief executive of a privately owned company, and obtained approval for it. They then changed the scheme so that it no longer qualified for approval and lost it. That enabled them to take the benefits free of the restrictions. In order to deal with this practice, the law was amended so that when a pension scheme was approved and approval was then lost, a 40% tax charge on the fund as it stood when the scheme ceased to qualify was levied. There is a number of statutory mechanisms for withdrawing approval from pension schemes. The one that we are concerned with involves the Inland Revenue in giving a statutory notice to the administrator of the scheme withdrawing approval with effect from an earlier date, usually the date in the past when it had ceased to qualify for approval. It may only be some years after a scheme ceases to qualify for approval that the Inland Revenue hears about it and withdraws the approval. That is what happened in this case. The John Mander Limited Pension Scheme was set up by the company for the benefit of its managing director and controlling shareholder and his wife. It was set up as an approved scheme but ceased to qualify in 1996. The Inland Revenue withdrew their approval in 2000, but with effect from 1996. Under the Income and Corporation Taxes Act 1988, the 40% tax charge arose at the time when the scheme ceased to have effect. The question which arises on this appeal is when that was. Was it in the tax year 2000 to 2001, when notice was given, or was it in the tax year 1996 to 7, when the notice took effect? This matters because there is a limitation period for tax assessments. The scheme administrator has been assessed for the year 2000 to 2001. If that is the wrong year, it may now be too late to reassess the administrator for the right year. The Revenue say that the scheme was approved until its status was changed by their decision to withdraw approval. That was in 2000. They say that it is irrelevant that when they withdrew it, they did so retrospectively to 1996. They add that any other view would be unsatisfactory, because in some cases they might not hear of the change which entitled them to withdraw approval until years later, in which case it might be too late to charge the tax. They add that even in a case where they discover the facts in time to charge the tax, if they had to assess it for the earlier year when the scheme ceased to qualify for approval, the scheme would be liable for several years of interest. These arguments were substantially accepted by the First-tier Tribunal, and on appeal they were accepted by both the Upper Tribunal and the Court of Appeal. The Supreme Court, by a majority of 3-2, allows the appeal and holds that the correct year of assessment was 1996 to 7, when the scheme ceased to qualify for approval, and not 4 years later, when the Revenue learnt of the change and gave notice withdrawing approval. All three members of the majority, Lord Neuberger, Lord Reid and myself, give judgments. Lord Hodge and Lord Carnworth dissent. In summary, the Court's reason is that the statute authorised the Revenue to withdraw approval retrospectively, i.e. with effect from an earlier date which had to be specified in the notice. When the Revenue exercised that power, the approval ceased to have effect at the date given in the notice. The Act then provided that the 40% tax charge was to be levied on the value of the fund as it stood at that time. There are supplementary provisions for ensuring that capital gains tax is charged on a subsequent disposal of the assets only on an increase in their value after the earlier date. The main point made in the dissenting judgments is that this involves applying the tax retrospectively, and there is normally a strong presumption against retrospective taxation. The majority consider that any element of retrospectivity is required by the statute, which expressly empowers the revenue to withdraw approval with retrospective effect. In a case like the present, this cannot be regarded as an injustice. When the revenue withdrew approval with effect from an earlier date, it was merely recognising the facts as they had been ever since 1996, when the scheme was changed so that it no longer qualified for approval. It is true that if the tax is assessed for the year 1996-7, interest will in principle be chargeable from that date, but that simply reflects the fact that the scheme continued after 1996 to receive tax benefits to which it had not been entitled. As for the suggestion that this view of the law prevents the revenue from taxing schemes if they only learn of the change some years later, the revenue has ample statutory powers for dealing with this problem by requiring the automatic provision of information to them about changes in schemes which affect approval. They in fact exercised these powers. The problem is that they did it only in 2003, too late to affect the present case. The appeal will therefore be allowed, and it will be declared that the Inland Revenue were not entitled to assess the special charge to tax in the year 2000 to 2001.
Thank you.